the other members of the Governors Association. I have direct calls with Jeff Zients, who's overseeing this. It's all about how many more can we get. And I had a direct call with the CEO of Pfizer saying, when this is available, remember, you're a home state business. We're happy you're here. We know you have your obligations to the federal government, but as soon as they are commercially available, we're number one in line. So yes, very much a focus. Dr. Best, anything else to say on the medications?
You've captured it exactly. The Paxlovid, the oral antiviral medication that seems to be most effective, is just in very short supply. We're urging the federal government to consider its distribution not only on a population basis, which is how they made the release of their first tranche, but on a disease burden basis. The 3,180 courses of treatment that we received as a state were distributed within the state on a population disease burden basis, so with New York City receiving a disproportionate share, but that obviously is just not enough. There are also the monoclonal antibodies. So Sotrovimab is also in short supply, although that the federal government has been given to us on a population disease burden basis, and we've received a disproportionate share of the national store for that one. We need more of these drugs in order to make them alter the course of the pandemic and reduce hospitalization. I'm sure you all know that these are for people at high risk of hospitalization. And so we want to diagnose them early. That's through testing. We do that. And then we have to be able to get them the drug. And that's the problem right now. There just isn't enough drug.
Thank you, Doctor. And with respect to Super Bowls, I'm very excited about the Super Bowl this year. Seeing what happens. I don't want to jinx anything, but I'm feeling good. Yes, what you're talking about is exactly what I showed in, I think, October 5th. I showed the holiday trends from last year. Halloween, December, religious holidays, Hanukkah, Christmas, New Year's Day, New Year's Eve. And then I said the next spike was Super Bowl weekend. The difference between this year and last year is we didn't have vaccinations. Everybody was desperate. As you hear Dr. Bassett talking about the short supply, that reminds me of 1 year ago when the vaccinations were in such short supply. And now we have boosters. So I would recommend, if you're going to gather for the Super Bowl, and I understand the desire to do this, keep your masks on, wear the smart masks, the ones that are more fitted, which are not as much fun, and they don't have like your favorite team's logo on them, but you can put that over it, as I properly demonstrated a few weeks ago. So just be smart about it. You know, we understand that is another point of vulnerability, and I would hate to see one weekend of games or 1 4-hour period of a game be the reason that what could be a plateau by then ends up starting to go up again. But that is still a few weeks off. We have some playoffs to get through, and we'll all see what happens in the next couple weeks. But yes, I'm sounding the alarm about that weekend as well. I called it out in October. I know that is a weekend that we are exposed to a lot more people getting together. So I hope we're in a better place by then. And based on this possible plateau, we could achieve that. Zach?
Governor, a couple of questions regarding a couple issues that I didn't hear you mention. Number one was bail reform. Is that something you feel like needs to be reformed this year, or are there not enough statistics yet to suggest that it does need changes? And secondly, the eviction moratorium, are you prepared to let it expire?
We're looking at both those issues, Zach, and these are conversations that I'm having privately with the leadership, and we'll be certainly letting the public know the outcome of those conversations. So to be determined, but people will be hearing our position on those very shortly. Mac?
Hi, Governor. For healthcare workers who may refuse to get the booster shot, do you worry that it could be an issue with hospitals that are already facing staffing shortages?
Well, first of all, 92% of all workers got the vaccination, which is quite extraordinary. I mean, that is higher. Don't have the data, don't quote me. I believe that's one of the highest in the nation. And so it's, to them, they overcame the hurdle. Some wanted to do it immediately, but those who had overcome a hurdle, I believe that they'll just view this as, I did it once, I can do it again. So we don't think it's going to be that level of challenge it was the first go-round when this was a new idea. That being said, we are already losing healthcare workers because of them getting, even testing positive without symptoms. They've been going home, and that has been a source of enormous stress on our health systems already. So if we get them the booster and they can get back to work faster without symptoms, that's you're talking about something exactly we had to calculate that. We had to make that determination together on assessing the risks and the benefits of each, but also seeing the numbers that we're losing healthcare workers and all these other workers who are so critical to keeping our systems, going, our healthcare systems going, that we think it's worth it to just ask them to do the right thing one more time.
And then just one more. Mayor Adams has talked a lot about wanting mandating COVID testing in schools, regularly for kids, but says he can't do that type of thing without state approval. The city comptroller earlier this week said, no, the city can do that. We don't need state approval for that. Any clarity on that?
Here's what we're assessing, and this has been the source of many conversations. We have been nation leading in ensuring that our kids get back to school. This started weeks ago with our efforts to make sure that they had sufficient tests. We did something that was just extraordinary a week ago. We actually going to be able to get them in the hands of schools in time. We did it. Not 2, but now 3 million test kits. So we believe that there are opportunities for the children to get those tests, take them home if necessary, if there's a positive case. We don't want to create a dynamic where if there's a requirement, a mandate, and then people say they don't want to follow it, and therefore there must be a remote option, now we've underdone exactly what we're trying to achieve, which is to get the children back in school unless they're testing positive, and we want to make sure that they're protected and safe at home. So that's the pressure. I mean, these are the competing interests here. I want to make sure that our kids are safe in school. As we saw from that spike, children got sick when they were home. They got sick being home. They didn't get sick in school. So we don't want them to revert to remote because there was a mandate that there be testing in schools. And that's what we're trying to balance. I wish parents would just be smart about this. But there'll be certain individuals who say, well, you have to give me an option. I don't want my child to test, therefore I'm going to stay home. Therefore, you have to set up the whole infrastructure to allow us to go remote again, undermining our desire and everything we've been focusing on, which is to make sure that children are not isolated, that they don't lose another day more than necessary of critical in-person learning.
Can the mayor make that decision, though?
Good almost afternoon, Governor. We're going to jump over to Zoom now. Your first question at
I'll get that afterward.
11:57 comes from Bart Jones at Newsday. Bart, your mic is open. Go ahead and open your mic, Bart.
Hello?
Okay, can you hear me now, Governor?
Yes, I can.
Okay, great. So, Governor, Nassau County Executive Bruce Blakeman is directly challenging your authority as governor by issuing an order that local school districts can do whatever they want regarding masks, and they don't have to obey your mandate. He's also issued an order that Nassau will not obey your mandate for mask or vaccine requirements in indoor public places. What do you plan to do about this public and blatant challenge to your authority as governor? And secondly, do you think it was a mistake to announce on Friday, December 10th, the indoor mandate, and then the following Monday announce that you won't compel counties to enforce it? Are people now looking at you as a pushover, or as some of your opponents contend that you have created chaos and confusion? Thank you.
I love those kind of questions. No, I don't think anyone could ever accuse me of being a pushover. They know me, and those who underestimate me do so at their own peril, including the county executive of Nassau County. I have the law of the state of New York behind me, and I will always exercise my authority and obligation to protect the health of the people of this state. That is what allowed us to follow Public Health Law number 206, granting the authority for us to require masking in schools. That law stands. That law supersedes anything a jurisdiction such as a county, which is a creature of the state. Municipalities are creatures of the state. They have to follow state law. In addition, the schools are also regulated by another entity known as State Education Department, who came out very strongly and said that they want this mandate to stand, that counties are required to enforce the masking instructions. And they also have an additional point of leverage, and that they fund all the school districts. Therefore, I feel very confident that our requirements will stand. I know that the School Board Association across the state stands with us, teachers stand with us, parents stand with us, and those who choose to defy that will understand that there are consequences and fines and cessations of funding, which I don't think the school districts will want to deal with in the first place. With respect to our requirement of masks or vaccinations, I have always said that we are going to conduct ourselves in a different approach and ensure that we empower localities to do the right thing. I believe that a mask mandate was the right thing to do, a mask or a vaccination, to give flexibility, which is important for businesses. I've spoken to thousands of business owners over the last 2 years about what they've gone through and what they want. They want people to be safe. They want their employees protected. They want to have the right to be able to institute that and have the state behind them, which is what we did, to make sure that they don't lose any employees or customers because of coming into an environment where people are not masked. So we feel we did the right, I know we did the right thing. We did the right thing with having that mandate. And in terms of enforcement, I believe that counties should be exercising their authority that's granted by the state to enforce this. Now, we understand that there are those who said they will not. I am appealing not to elected leaders who are not taking their responsibility seriously to protect the public health. I'm appealing to the businesses. And I am so grateful to the so many who have followed what we've asked them to do, protect their workplaces. And here's the whole reason we do this as well. I've always said we're doing everything to protect the public health, but also the health of the economy. And to the extent that we can avoid ever having to go back to those dark days when businesses were literally shuttered, destroying the livelihoods and the dreams of thousands of people because we were in the throes of a pandemic without resources, without enough masks to go around, without vaccinations, a very different time. So many lessons were learned from that experience. And I have said from day one, I will not shut down the economy, but will make sure that businesses know that they have the state of New York standing behind them when they institute a mask requirement or a vaccination requirement for people to go in them. So it's a different approach. It works. We're standing behind it, and we'll leave it at that.
Thank you, Governor. Your next question this afternoon comes from Tim O'Shea of the Buffalo News. Tim, your mic is open.
Hi, Governor. I'm going to switch topics on you for a moment. You alluded to the Super Bowl before, so I'd like to ask you about the Buffalo. I'd like to ask you about the Buffalo Bills stadium negotiations. How are things going? How soon do you hope you might be able to make an announcement? And also, there's a lot of talk upstate here about a dome versus an open air stadium. Do you have a preference on what kind of stadium you'd like to see?
Well, when there's 18 inches of snow on the ground, a dome always sounds better, but I do believe that part of the culture of the Buffalo experience is to have the outdoor. And this is a conversation we had with the owners, the Pagulas organization early on, to talk about when we conducted a study of options that we would put forth different locations, study dome versus not domed, and presented that to them and talked to them collaboratively about what the best approach would be. And it was determined, the preference was for Orchard Park, to keep it where it is, look at that site instead of downtown, and also to keep it open air as part of the Buffalo bravado, which people love to showcase. In terms of negotiations, conversations have been ongoing literally for months, very positive, and there is not a date certain other than the next few months where it has to be completed, but I like to get this done, wrapped up sooner than later, but that doesn't mean that we don't want to make sure that it's done in the smartest and the best way, so we'll devote the time necessary to achieve that.
Thank you, Governor. Your final question this afternoon comes from Tim Balk of the Daily News. Tim, your mic is open.
Hi, Governor. Can you hear me?
Yes, I can, Tim.
A question for you, or possibly Dr. Bassett, which is obviously you can't predict the future, and there have been inconsistent data points globally, but do you guys have any sense or any projections of how long, if we're peaking right now, how long we're going to peak, or any expectations of that?
Let me dust off my crystal ball here, because that's about all we've got, Tim. I wish I had more to go on than that, but Dr. Bassett, how's your crystal ball looking these days?
Well, I keep thinking of that famous saying that it's hard to make predictions, especially about the future. But but we know that this is a much milder variant than the others. That's what you've been hearing in the numbers all day during this press conference. And elsewhere, they've gone up quickly and come down. We need a couple more days to be able to tell that it has peaked. Of course, that's what everyone is hoping for. It will end. That much I'm prepared to make an assured statement about. And I think that we can expect a difficult January, but that things should be much better by February. But as ever, we just have to keep tracking the data day by day.
Thank you, Dr. Bassett. And again, to Juliet, Mac, and Zach, thank you for having the fortitude to bundle up and come out here in a sun. To those of you in the rest of the state, it's actually sunny and nice here. But Mother Nature heard that someone from Buffalo was in charge, so she just kind of stood down this time. I don't say that with arrogance because I know there's another one coming. But I want to thank everybody, and especially my team here. Extraordinary leadership at a time when we need to be surrounded by the smartest people, the most people know how to operationalize. I have a lot of ideas, but this is the team that actually executes. And so I'm really proud of them, and I want to thank everyone who helped on the state address. Scores of people who put their heart and soul in a lot of long nights. We did something in a very compacted time frame. Next year, we're going to start working on it in May, so we don't have those long nights throughout the month of December. But again, I have an amazing team, and I want to thank all of them for being the true definition of public servants. Thank you.
I think is where the sentencing inquiry for Mr. Bryan really begins, because this is a kind of unusual case. To me, there are 4 additional factors that the court has to consider in fashioning a sentence here. And then the question becomes how the court does that under the laws of our state. We've already challenged those laws. The court, not surprisingly, given prior decisions of our Supreme Court, whatever standards may be evolving until the Supreme Court says they have, this court applies the law that we have. But there are 4 factors here that I think the court has to the court never has to consider anything I think the court should consider. Issue number 1 is the jury verdict says that Roddy Bryan was not a party to the shooting, nor a shooter. Roddy did not kill Mr. Arbery. He did not attempt to kill Mr. Arbery. He did not intend to kill Mr. Arbery. He had no idea that the McMichaels had guns until moments before the shooting. And that's not just an opinion, that's pretty much the jury verdict. When they acquitted Mr. Bryan, not only of count 1, but also count 2 and count 6, when they found him not guilty of anything related to the shooting, that's a reflection of the fact that Mr. Bryan had no idea of what was about to happen. That tragedy was certainly not something that he could have anticipated up until the moments before. And by saying that, I'm not trying to get back into the charge conference issues. It's a different factor here at sentencing. But Roddy Bryan was not a vigilante. He was not a party to any organized effort to fight crime in Satilla Shores. Roddy Bryan really had no idea what was going on or why until after the tragic death of Mr. Arbery. And I think the state pretty forcefully drove that issue home during its closing argument in this case. That factor really puts Mr. Bryan in a different position. Mr. Bryan isn't the one who brought a gun. He was unarmed. And I think that reflects his intentions and it reflects a significantly lesser state of culpability. The second issue, Your Honor, is the issue of remorse. Now, like the McMichael defendants, Mr. Bryan faces a federal trial and substantial federal penalties in the event of a conviction. And I would agree with Mr. Rubin that no competent attorney in the state of Georgia under these circumstances would allow a defendant to say anything more than they already have. But in this case, distinguishing again Mr. Bryan from the McMichael defendants, Mr. Bryan has expressed remorse. Whether it's part of the record or not, he expressed remorse about Mr. Arbery's death even before he was arrested on national television. As the Arbery family, of course, has not accepted that, and they don't have to, Your Honor, and we could all understand why. But beyond that, when you look at his statements in this case, I think it is readily clear that while Mr. Bryan has disputed and continues to dispute whether things that he did that day constituted crimes, he has never questioned the tragedy of this death and has never expressed anything but remorse over the death of Mr. Arbery. And that does put him in a very different category, I would submit, and a very different posture from the other defendants. And I would remind the court, and I'm not going to spend a lot of time on it because the court heard most of this, but during the trial, the court heard the body cam from Mr. Minshew. Mr. Bryan admitted from the get-go that he chased after Mr. Arbery, that he was uncertain as to whether they should have done that. He wasn't running around the scene trying to influence witnesses' testimony, as the state alleges other people have done. He was very candid and straightforward, and you heard his demeanor on the video at the crime scene. You heard the excerpt from the interview with Detective Lowry, and of course the court has the entire statements in the record, where Mr. Bryan expressed, again, regret that Mr. Arbery died. He pointed out that, if his vehicle had collided with Mr. Arbery, maybe Mr. Arbery would still be alive. And not in the context of wanting to hurt Mr. Arbery, but in the context that maybe he would still be with us. And this tragedy might have been something less. Beyond that, Your Honor, there were a number of statements made to investigator Sechrest, Special Agent Sechrest, during the investigation of this case, which technically, I believe the statements themselves, the transcripts and the videos were admitted into evidence at the Jackson v. Deno hearing. At least that's my practice. I don't have a transcript to look at, but that's normally what I do. And moreover, I think they were tendered in connection with the preparation for the trial itself, and I think technically during the trial, although they weren't presented to the jury, but the court can consider those. On May 11th, Mr. Bryan, I'm referencing page 69 of that transcript, indicated that he did not want to see the video in the aftermath of the shooting. He didn't enjoy it. He didn't take any pleasure in that. On May 13th, at page 75, Roddy Bryan expressed shock to Agent Sechrist at the shooting of Ahmaud Arbery. Referencing page 100 of the transcript, Roddy thought it was that what Mr. assumed, thinking might be putting too much credit to Mr. Bryan, Roddy Bryan assumed that Mr. Arbery had done something more serious, that there was more to it than going through an open, unsecured construction site. And that doesn't change the lawfulness or unlawfulness of his conduct, but it does reflect on his level of remorse. At page 101, Mr. Bryan says that to Agent Sechrist, and these are all statements that the state could have used at the trial against him had they wished to do so, and may still be used against him in federal court. None of these statements are without consequence. That he was sorry that Ahmaud Arbery died, that he wished he had stayed on his front porch. He's not going around boasting to people or bragging about it. He's regretful way back then. And that is before he was arrested. At page 102, he regretted having got involved in the chase. And, Your Honor, I think when you take those statements in conjunction with the rest of the evidence in this case, Mr. Bryan has done everything he could do, short of confessing to committing felonies on national television, that he is remorseful and regretful at this tragic loss of life. And it's difficult for me to conceive what more he could do. Now, is the Arbery family going to be satisfied with that? No. They don't have to be satisfied with that. You have to give credit. 3 members of his family came up here and probably did what were the most difficult things they've ever had to do, is to come speak here in this court on national television effectively about the death of their child and their brother. And that's difficult. But whether or not they accept Mr. Bryan's expression of sorrow and remorse for the death of Mr. Arbery, it's for the court to decide whether Mr. Bryan has expressed remorse, and if he has, what to do about it. And the court may well decide there's nothing the court can do about it. The felony murder statute prescribes one punishment, a mandatory minimum of life. And I'm not reviewing the legal argument there. But if there's a way the court can take it into account, I'm going to argue that the court should. The last issue, Your Honor, and I think the court is well familiar with it, is Mr. Bryan's full cooperation with law enforcement from day one, from moment one, from minutes after the shooting. I'm not going to belabor all the different things Mr. Bryan did, producing the cell phone, the night out video, the numerous statements, going through the area where the shooting took place with the police to help them understand what happened that day. On a scale of cooperation, you'd have to put Mr. Bryan at a 10 out of 10, even a 12 out of 10. I've never seen a defendant provide that kind of cooperation. Most of it without the benefit of counsel. Slick lawyers didn't tell Roddy Bryan to turn over the cell phone, to talk on the scene on the body cams, to go down hours later to the police department. Roddy Bryan did that because he wanted the truth to be known, whatever that was, whatever it meant. So these are all factors above and beyond anything that apply to the McMichael defendants as to why Mr. Bryan should receive a lesser sentence. Now, the mandatory minimum in Georgia is life imprisonment on a felony murder. I'm not going to rehash the legal arguments. What I am going to suggest to the court, though, and given the age of the defendants here, whether Mr. Bryan is eligible for parole or not, he's going to be 80 years old under the current guidelines before he could be eligible for parole. And effectively, even if the court grants life without parole sentences, as the state has requested, to the McMichaels, simply giving Mr. Bryan a sentence of life with the possibility of parole, still, given the respective ages, means that he would essentially serve the same sentence and that there would be no options there. So I'm asking this court to consider sentencing Mr. Bryan and Mr. Bryan only under OCGA 17-10-1B, which, at least in my experience, is relatively rarely employed, but perhaps underused, especially given the evolving standards of with respect to sentencing issues. Under 17-10-1B, as I understand it, a request for relief from parole restrictions may authorize consideration by the parole board of parole prior to the completion of any specified time period otherwise required prior to parole eligibility. Imposing sentence under this statute does not grant Mr. Bryan parole. He still may never receive parole. He could still die in prison 50 years from now, even if the court grants relief under 17-10-1B. All that does, however, is it gives the parole board the freedom, if you call it that, the ability to parole Mr. Bryan whenever they see fit, regardless of any statute or rule that would otherwise prevent it. Now, Mr. Bryan still has a long road here to establish the redemption and the rehabilitation that would justify his ever being released from prison. So, as I've explained to Mr. Bryan, this doesn't guarantee him that he would do 1 day less in prison than he would otherwise do under the sentence that the court is about to impose. But what it does do is provide the opportunity for the parole board to exercise its discretion in deciding whether to release Mr. Bryan when they believe it would be appropriate and not based on some arbitrary, preconceived, mandatory minimum time period before he could be considered. And I believe that this is that rare, exceptional case where relief under 17-10-1B, however fleeting it might be, depending on the circumstances, that this is a case where that would be appropriate. And I would respectfully submit to the court that as a practical matter, it's really the only relief that the court can give Mr. Bryan to reflect his cooperation, his expression of remorse, and the other factors that I've reviewed with the court today. And that doesn't change the sentencing recommendation. I'm concurring with the state, putting aside the legal arguments about merger and vacating of sentences. I'm agreeing with them that the sentence of life plus 15 consecutive probation, that would be the appropriate sentence in this case. I think the only thing that we really are disagreeing about at this point is I'm expecting the state is not going to be excited about 17-10-1B, but I'm asking the court to do that anyway. And in this relatively small instance, and again, it may be completely meaningless depending on how the parole board views things 10 and 20 years down the line, but it is really the only thing, short of striking down parts of Georgia's sentencing law on constitutional grounds, it's really the only thing this court can do that would substantially reflect the wide chasm in differences in culpability and other issues between Mr. Bryan and the McMichael defendants. It's all that this court really has available to do that. And if for no other reason, that's why I would ask the court to do so. But I do think it would be in the best interest of justice. I mean, Your Honor, Roddy Bryan probably, I won't say he's unique, but he's as close to unique as you can get in our criminal justice system. It's a felony murder for someone who didn't kill or attempt to kill or intend to kill, and it's in the context of a citizen arrest, however foolish and badly guided and misinformed, and certainly however unjustified under the law. There probably isn't another individual in the entire Georgia prison system that's in a similar posture, and thanks to the changes the legislature has made to the citizen arrest statute, it will certainly never be an issue again. So this is a request that we're making here on behalf of Mr. Bryan that would effectively impact one person now or in the future in the state of Georgia. And we're not asking that as special treatment for Mr. Bryan. We're asking it as treatment that anyone in his situation would be asking for, given the totality of circumstances present to the court. So again, we're asking the court to impose a sentence of life imprisonment plus 15 years, but we're also asking the court to grant relief under 1710(1)(b). Thank you, Your Honor.
Thank you, Mr. Goff. From the state.
Thank you, Judge. Because there's a number of legal issues as well as additional argument by the state, is there any particular order you'd like to hear it in? Would you like me to start with Mr. Bryan first and work backward, or just go from Travis and...
Why don't we, however the state wishes to present it, I'll be able to follow it, I would imagine.
Wonderful. Okay, Judge. So regarding Mr. Bryan, with regard first to this parole board issue, 1710(1)(b) actually says that it will apply only to first offenders, where technically Mr. Bryan is a first offender. He doesn't qualify under the first offender statute because anyone convicted of felony murder, you're not allowed to sentence them under the first offender statute. So we have that problem first. But the second problem is that it refers back to A. And subsection A of 1710(1) actually says, except in cases in which life imprisonment, life without parole, or the death penalty may be imposed, and then goes through. So B can't even apply to anything that imposes a life sentence. And that's how the state is reading this, because when you look at B, the judge, in fixing the sentence as prescribed in subsection A of this code section, subsection A says except for life sentences. So therefore, none of this will ever apply to a felony murder conviction. Conviction. And then looking at count 9 merging into count 8. I understand factually the issue that Mr. Goff has brought up on behalf of Mr. Bryan, that two separate instances, one an attempt to confine him taking place on Burford, was just a continuation of something that was going on and on and on and on. Ironically, that was not the argument that Mr. Goff made at trial during his closing argument. he actually started to posit that Mr. Bryan was actually leaving and wanting to go home and just happened to go in the wrong direction back down Holmes, and that he wasn't actually trying to commit a false imprisonment on Holmes. He was just trying to go home. But regardless, what we have here is an intervening factor. I didn't know Mr. Goff was going to make this argument, but I believe there's a case out there that involves aggravated assault and aggravated battery. And it involved a man who had cut the female victim's throat and then also cut her face. The aggravated battery was on the face, the aggravated assault was on the throat, but there was an intervening time frame. And so on the one hand, I do know that there are numerous cases out there where if you start shooting at somebody and then continue to shoot, it's all one aggravated assault. Okay, there aren't separate aggravated assaults for each time you fire, unless there is an intervening actual time frame where you've shot, they've run away, you've chased them down, and now you're over on another street, like we have in this case, you've encountered them again, and now you start shooting again. Because there's two different locations, two different specific places and times, that allows the state to charge it. And the reason it allows the state to charge it is because what you're really trying to do is prevent the state from engaging in double jeopardy. You don't want the state to be able to go on January 3rd on Burford, no, well, I'll do our case. On February 23rd, 2020, on Burford, he attempted to falsely imprison him. Oh, not guilty. Okay, well, we'll go ahead and move it over to Holmes, and we'll get a new indictment, and we'll do it over there on that date. So you want to keep the state from going ahead and doing two different things in two different bites of the apple. You want to make sure there's no double jeopardy here. Well, in our case, we don't have double jeopardy here because we have two different separate instances, and they're both in this indictment, and they're both two separate time frames. Yes, very close in time, between 4 minutes. I know I'm kind of giving the court both the defense side and the state side, but to be candid with the court, there are cases out there, especially the gunshot cases, that say it's all one continuous action. The state's position in this indictment, and one of the reasons we specifically indicted it this way, is because Mr. Bryan's attempt at false imprisonment on Burford was specifically done with his pickup truck when he tried to run Mr. Arbery off the road and tried to attempt to falsely imprison him right there with his truck. He attempted 4 different aggravated assaults on him at that point in time to get him to stop there. He was unable to do it. That's why it's a criminal attempt. However, over on Holmes, after he went up and chased him up, and then we begin the video, and Mr. Arbery turns back, Mr. Bryan does continue to go up Holmes. He actually goes up Holmes. It's on video. He pulls into a driveway. He says, I'm going to go ahead and keep going. He does a 3-point turn, and then he comes down Holmes. He encounters then Mr. Arbery coming around the corner, and that is where that actual false imprisonment absolutely takes place, right there on Holmes, where Mr. Arbery is ultimately falsely imprisoned and killed. So these are two separate, distinct incidences, and there is no chance of double jeopardy because both of these things are distinct. They took place at separate places and separate time frames within the incident. So we ask that count 9 not merge into count 8 for Mr. Bryan.
I'm sorry to interrupt. I'm not sure because of the way we're doing this. I did want to point the court to another case with respect to this issue that's been drawn back to the merger issue that I raised. And that is, the point is whether or not it's a continuing offense. Kidnapping is a continuing offense. So for example, if someone is moved, an asportation occurs, all the places during that movement are one crime. And I'll cite to the court Hill versus the state, 279, Georgia App 666, a 2006 case that's cited in Brower versus the state, 298, Georgia App 699, a 2009 case. It says that the offense of kidnapping is complete when, in this instance, Brower sees the victims, forced them to the back office in the case of the office staff, and when he taped up and moved the attorney from place to place in the office. So the movement is the question is, if kidnapping is not a continuing offense, then is false imprisonment, and I've done a search and I just don't have the answer to that.
And yeah, we'll keep the state to its argument. understanding that with the kidnapping, the issue here, I think, is slightly different. As I understand what the state's arguing is the way that false imprisonment and the attempt was alleged in the indictment was that the attempt occurred on Burford. There was an intervening interval. And then later, short period later, but later, there was a completed act on Holmes. Okay, that's the argument that I understand is being presented. And that's why I'm going to look at the merger part of it. Now, how that fits and whether or not it merges, I'm probably going to take a few more moments to think that through and how that works. But that's what I understand we're looking at as far as the legal issues. I understand the kidnapping part of it. You have a kidnapping, just because you move them within the office, we're not going to allege it. Flip side of that is, I mean, you look at some other statutes like the, and I won't tip at windmills, but when you look at police chases, I mean, you can be charged with obstruction 5 times in the same chase. So, I mean, the issue may seem simple, but it's not. But this is the way I'm going to approach it. Okay.
Thank you, Judge. And I believe the reason for the merger really comes down to the issue of double jeopardy, because you have to put the defendant on notice, because you do not want there to be an opportunity for the state to come back with double jeopardy, which is why you want to get as specific as possible, and which is what we did in order to designate these 2 separate instances in time and in place. So that is the state's argument as far as count 9 merging into count 8. And that is what I have for Mr. Goff. Now, Your Honor, with regard to the legal argument that Ms. Hogue made on behalf of Greg McMichael, actually, Noel was then cited in the case of Jeremy Scott, who killed Dexter Holliday. It was a Fulton County case. Embarrassed to say it was my own. And in that case, we had to resentence Mr. Scott because what the court did was sentenced him on the felony murder conviction, but then actually when he was found guilty of possession of a firearm by a convicted felon, the court went and took the possession of a firearm by a convicted felon, merged it into the felony murder, then merged the felony murder into the felony murder for the armed robbery. And the court went and cited to Noel. And this is Scott versus the State, 302 Georgia 29. It's a 2017 case. The state notes that, based on Noel versus the state, the trial court erred in merging the felony murder convictions and then merging the predicate felonies into the remaining murder conviction. When the trial court sentenced Scott on count 2, the felony murder based on aggravated assault, count 3, felony murder based on possession of a firearm by a convicted felon, was vacated by operation of law. Therefore, count 6, possession of a firearm by a convicted felon, then cannot merge into count 3, which stands vacated. We therefore vacate the merger of count 6 into count 3, meaning the possession of a firearm by a convicted felon, into the felony murder that it's based on, and remand for resentencing on count 6. Now, factually, you are a convicted felon at the moment you're shooting that person. It happens at the exact same time. So I think that kind of goes towards that, well, if it's all happening at the same time, it needs to merge together. And I will also direct the court to a case I affectionately call the El Camino case. Once again, unfortunately mine. This is DeMarcus Graves. It is Graves versus the State, 298 Georgia 551. Once again, a 2016 case. And at that point in time, basically it said, while the evidence was sufficient to sustain Graves' conviction, we find an error in sentencing. The trial court purported to merge 2 felony murder counts with the malice murder count. The trial court then purported to merge 2 independent felonies, criminal attempt to commit armed robbery and possession of a firearm by a convicted felon, with the 2 murder counts. And basically what they said in Graves was, no, you can't merge the felony murders into murder. You have to vacate them by operation of law. And once they're vacated by operation of law, that's going to leave you with the possession of a firearm by a convicted felon and the criminal attempt to commit armed robbery. Therefore, the trial court is required to vacate that portion of its sentencing order purporting to merge the 2 independent felonies and impose proper sentences on those counts, which I then had to go ahead and do and resentenced Mr. Graves to the murder charge with those two particular felonies. So there are two cases right there that show that that is not the case, because they murdered Mr. Graves while attempting to rob him of his drugs while he was sitting in his El Camino in the parking lot of an apartment complex while being convicted felons. All of that took place at the exact same time. So therefore, Noel does not stand and has been overruled basically by Scott and Graves. So with regard specifically now to Greg McMichael, the idea that there was no vigilantism here because after they confronted people, after they took their guns to confront people, after they confronted those people with those guns, then they would call the police, is somehow a neighborhood watch situation. As Officer Rash testified, they're supposed to be witnesses. That's what neighborhood watch is there for. They're supposed to be great witnesses. Officer Rash said he thought Greg McMichael would be the best witness, being a prior law enforcement officer, that he'd be able to come in and take the stand and say what he saw. That's what neighborhood watch is supposed to be, not somebody running after people in a residential neighborhood where there are women and children and people out walking on a regular basis. This was a Sunday afternoon. It's a miracle they didn't run into families taking a walk that day. And on a random day, when the GBI went out with the drone videos and were just going through the neighborhood, they captured numerous people out taking a walk. A family with children were there. So the next point, that Greg McMichael has shown no remorse or empathy because he's unable to. Well, Greg McMichael was a law enforcement officer. But what he did on May 5th of 2020 was release evidence in an ongoing investigation into himself and to his son. Greg McMichael's the one who released the video to the media. He went to Mr. Bryan and said, hey, give me your phone, I'm going to take it to my lawyer, took it to his lawyer and had his lawyer release it publicly because he believed it was going to exonerate him. That's interference with administration of justice. Yes, we did not charge him with obstruction or anything like that, but the fact of the matter is this is someone who was in law enforcement for years and actually actively pursued evidence in a case against him to be released to the media because he believed that that video showed he and his son were not guilty of anything. That's 2 months afterwards. The state's position is he hasn't changed his mind. The state's position is he and his son still believe they didn't do anything wrong. And that is a lack of remorse or empathy. The idea that he did not intend the death of Ahmaud Arbery, once again, he's a law enforcement officer, got a gun, went running after somebody. The jury did find that he intended to commit false imprisonment, criminal attempt at false imprisonment, aggravated assault with that pickup truck, and aggravated assault with that shotgun. And we all know that felony murder has a foreseeability component to it. Ahmaud Arbery's death was foreseeable, and especially foreseeable to someone in law enforcement. The idea that they wanted to get to the bottom of what an unknown person was doing in some neighbor's house, a neighbor they didn't even know, goes back to our vigilantism. This whole idea that they were trying to help the neighborhood out has been an excuse from both Travis and Greg McMichael. Ms. Hogue got up here and said, this wasn't advancing the progression of the crime. And I apologize for this once again, Your Honor, but stop or I'll blow your fucking head off. I think that really advances the progression of the crime. You're threatening to murder somebody. You're threatening to kill him if he does not stop. And referring back to the post records produced in the bond hearing, Greg McMichael was so not paying attention to his job as a law enforcement officer that he was not post-certified from January of 2006 through 2014. He was an investigator in the district attorney's office, and he let his post-certification lapse from 2006 to 2014, 8 years. I won't even go into what that could have meant to those cases that were prosecuted by the district attorney's office. He then lost the post-certification again in 2018, and Jackie Johnson had to make an accommodation and change his designation at his job just so he could keep his job through retirement. This attitude of I'm special and I'm above the law and the law doesn't apply to me and I can take my gun and I can run after people and confront the homeless guy under the bridge and then call the police later about it. That's vigilantism, and that is the main reason. The thoughtlessness, the remorselessness, the desire so to be special and protect himself and his family by taking evidence and releasing it publicly when he knows there's an ongoing investigation is the reason we are asking for life without the possibility of parole. And with regard then to Travis McMichael. There's a reason, Your Honor, you did not grant bond to Travis and Greg McMichael. Mr. Rubin went back to all of those things listed in the bond hearing. The state will also direct the court to things the state presented in the bond hearing, including his text messages with all of his offensive racial animus and language. The jury did find that he had an abandoned and malignant heart. That's exactly what the jury found. They were given that he intentionally went ahead and did this, or the other level, abandoned and malignant heart. In addition, I will remind the court that there's an old saying, the road to hell is paved with good intentions. And it's great that they had such good intentions to protect the neighborhood. But the thoughtlessness, the lack of vision to know how this could go terribly, terribly wrong. And the fact of the matter is, Your Honor, it was a year and a half. February 23rd, 2020. November 2021. Travis came in here and testified. The state asks that you take into consideration his demeanor, his attitude. He said, this was the worst day of my life. Well, how'd that work out for Ahmaud Arbery? Not once did he show any empathy or ability to place himself in the position of Mr. Arbery on the stand. And yes, 4 minutes of conduct. Well, 4 minutes of conduct. Usain Bolt won 8 gold medals. When he runs those races, they're less than 2 minutes long. But the reason he's able to do that, the reason he is able to win, is because of 20 years of training that leads him to those 2 minutes. Those 4 minutes are a reflection and a result of an entire lifetime of Travis McMichael and his attitude, his demeanor, what he believes he's entitled to go ahead and go do. The same applies to Greg McMichael. That 4 minutes of conduct wasn't just 4 minutes of conduct. It was a culmination of vigilantism. We get to go ahead and play law enforcement even though we're not, and that we're going to go out and confront people, and we're going to take our guns to go do it without any real understanding or consideration of the consequences. At this time, for Travis McMichael, these are the reasons that we are asking for life without the possibility of parole. Thank you, Your Honor.
All right. That being all argument and evidence presented, and I say that just to be clear on the record, there had been some discussion with counsel about evidence and the record. The court is going to leave the record open, as I understand it, for what's going to amount to a notice of filing and 2 affidavits, just in order to preserve arguments made during the trial on appeal. I'm going to take about 10 minutes, maybe 15 minutes, and go through my notes, and then the court will pronounce sentence. We are in recess for 15 minutes. All right, we are back on. The defendant is represented by counsel. All right, the way the court's going to address this, I'm going to make a few remarks and then address each one of the defendants with regard to sentencing. And the remarks are intended to be general, but also taken into consideration in the individual sentencing portion of the court's statement. So that's how we intend to proceed. So the court has heard the evidence in the case, has accepted the jury's verdict, listened to the presentations here today in aggravation and mitigation, and candidly have spent a lot of time thinking about this. This is a case that has taken a lot of time and energy on a lot of people's parts, and has been a case of note, not just in this community, but really in a lot of communities. But what we're here today to determine is what an appropriate sentence is, quite separate from the notoriety of the case and any other outside influence that may exist. And so the court is going to be very careful in explaining that the court has considered just the evidence and what is appropriate under the circumstances of this case to consider in the Superior Court. So that all being said, let me start with this statement. As we all now know, based upon the verdict that was rendered in this court in November, Ahmaud Arbery was murdered. It's a tragedy. It's a tragedy on many, many levels. On February 23rd of 2020, almost 2 years ago, a resident of Glynn County, a graduate of Brunswick High, a son, a brother, a young man with dreams, was gunned down in this community. As we understand it, he left his home apparently to go for a run, and he ended up running for his life. He entered the English home at approximately 1:04 p.m. and left that home at about 1:08 on that day. At 1:14, Greg McMichael calls 911 to let them know that there's a black male running down the street. And within moments, Ahmaud Arbery is shot and killed. The three men that are now before this court chased him in a residential neighborhood for at least 5 minutes in pickup trucks, armed with a shotgun and a .357 revolver. The state mentioned this today about the time period, but I do want to put that time period in context. And the only way I could think to do so may be a little theatrical, but I think it's appropriate. I want us all to get a concept of time. And so what I'm going to do is I'm going to sit silently for 1 minute. And that 1 minute represents a fraction of the time that Ahmaud Arbery was running in Satilla Shores. That's approximately a minute. Again, the chase that occurred in Satilla Shores occurred over about a 5-minute period. And when I thought about this, I thought from a lot of different angles, and I kept coming back to the terror that must have been in the mind of the young man running through Satilla Shores. The jury heard the evidence and returned a verdict. And what a difficult job they had under the circumstances. Without any comment on the verdict itself, I think all counsel will agree and accept that this was a very difficult case to even get a jury impaneled on. And there are issues out there with regard to the jury that were brought up in the press and elsewhere. But I want to give credit to those members of the panel, not because of their verdict, just because of the fact that they were willing to go through the process that they went through with the state, with the defense, and with this court. We're here today to sentence the defendants.